a really interesting estate litigation case, actually, here homegrown in BC, with a motorcycle rider who had a couple of different families. Do you want to maybe talk about how that can affect, and now that case is settled and we can actually talk about it as public, how that can affect the estates going forward? Because there were a lot of moving parts in this one.
Yeah. So I know the case you're talking about. I will say I don't know if it has settled, but that issue has been resolved with the court. And essentially, the case was brought forward by a woman who was seeking to be considered a spouse under WESA, the Wills Estate Succession Act, because her partner died without a will. And under WESA, when you die without a will, there is sort of a format that you follow. The spouse has a preferential share, and then if there are children, then there's an outline of what share they get as well. I guess the wrinkle in this case is that this woman wasn't the only spouse that the deceased had.
Right.
In fact, he had been living a double life. He had a wife. He was legally married, and he had a wife on the mainland, and they had 2 children. And some years later, he started a relationship with a woman on Vancouver Island, and they also had children. Now, I think we'll say spouse number 1 and spouse number 2. Spouse number 2 knew about spouse number 1. But it seemed like a tired old story that there were promises made that he was leaving his wife and he would, be full-time with his second family, but that never happened. He passed away unexpectedly. And so the court decision was all about whether 2 spouses can be recognized under WESA. Because WESA holds the definition of a spouse to be someone with whom you are living for 2 years in a marriage-like relationship. And he was going back and forth and spending extended periods of time with both families. And ultimately, at the end of the day, the court found that, yes, WESA does contemplate a situation for purposes of inheritance that there can be 2 spouses. I think it's an unfortunate situation for both of these women and also their children. It's quite a shock, I would expect, to have this publicly aired. It was all over the news. And that's why I say I don't know if it's settled. This element was settled. And so now it was really left for these 2 spouses and their children to determine how the estate could be divided up, given that they both had some preferential entitlements and then would be sharing with all of the children. So I think I say we as the royal we've got to be careful about being mindful of the consequences of our actions, which is something that I had mentioned earlier, sort of one of the mistakes that people make. Firstly, this person, this will, he wasn't even a will maker, this intestate deceased didn't have any plan. Knowing that he had 2 families,
Right.
He still had no plan. And unfortunately, it was left for these 2 women to publicly kind of pick up the pieces. Some people ask, well, isn't this the court legitimizing polygamy?
Right.
And that was addressed. And the judge said, no, this isn't a family law matter. And WESA seems to leave open the opportunity that people have 2 marriage-like relationships at the same time or at some points in time overlapping, and leaving aside the question of whether this was polygamy, because there was a legal marriage and then there was a marriage-like relationship that was recognized by WESA. Whether or not that would be a common law marriage for purposes of family law, that question was not addressed or answered.
Right. So that's up to them to decide.
That's right.
Right. And then another case that we actually talked about before this, where they were in a marriage-like relationship and then they weren't, and then they were, and then they weren't. And do you want to talk about that? There was 2 women.
Yeah. So this was a sad case, in fact. There were two spouses in a relationship, and a reasonably long-term relationship. They were not legally married. They were in a common law relationship, which of course is a legal marriage, but I want to make that distinction.
Right.
Because it's important for the WESA analysis that they were in a common law relationship. They had some challenges because the deceased, toward the end of her life in particular, had some mental health issues and was sort of erratic in some decision-making. One of the important things as well, which is a complicating factor, is that for cultural reasons, the deceased had not disclosed her same-sex relationship to her family, who primarily lived out of country. And so I suppose it was a shocker when the deceased passed, and then it came to light that she had at some point had a spouse, a same-sex spouse. And so it was the family of the deceased who was actually pushing in this application. The deceased died without a will, so it was another intestacy like the other case. And the application was all about whether the spouse was indeed a spouse, because it was an all or nothing. If she was a spouse, there were no children, she would inherit 100%
Right.
of the deceased estate. If she was not a spouse, then the estate would go to the family and whoever was remaining, either parents or siblings. The wrinkle in all of this is during some of the ups and downs, the spouses entered into a formal separation agreement,
Right.
which by all accounts, we're encouraging people to document things and to plan and to protect your assets. So that was very smart. The document ultimately was found to be a financial separation rather than a dissolution of their relationship. This is actually a really interesting point, because if they were legally married, the separation agreement would have been a separation,
A total separation.
per WESA. Because they were in a common law relationship, the analysis under WESA is a bit different. And so while this was a financial separation, the judge found that it was not a formal separation for purposes of WESA. And so at the time of the deceased's death, notwithstanding the financial separation, they were still in a relationship. There was no separation. And so the remaining spouse was indeed found to be a spouse.
Yeah. Get your will written. If you have one, make sure it's updated. Talk to your parents. Make sure they have a will written. And if they have one, make sure it's updated. Talk to your parents. Talk to your kids. Talk to your brothers and sisters. Generally, communicate, set expectations to help you in all aspects of life, not just in your estate plan.